there are two cases that are just so spot on for this moment. The first is the original Supreme Court case that really defined the contours of public employees' First Amendment rights. And that's called the Pickering case. And you may have even heard that word or name. I mean, that was an actual gentleman who was plaintiff in this Supreme Court case. And Mr. Pickering was a bit of a community gadfly, and he was also a high school teacher. And he was really mad about a funding decision that his local board had made. I believe it was a school board. And he went to the meeting of the school board, and he gave a rather impassioned diatribe against the local politicians and told them that they were wrong-headed and doing the wrong funding thing. And unsurprisingly, his supervisors did not like that because they made him look bad, and he said they were mismanaging money. And they fired him. And he challenged his firing under what was then still a fairly baby First Amendment that was still kind of getting its legs under itself in the 20th century. And this is in the 70s when this happened. And Pickering, it goes all the way up to the Supreme Court. And not only does the Supreme Court for the first time say, hey, public employees maintain their First Amendment rights even when they're working for the government as their employer. And they went farther than that. And the reason I'm just pointing this out is because he was a high school teacher. And in that case, the Supreme Court said, look, not only should public employment not serve as a muzzle, right, on someone who is doing their job as a public servant, but indeed, we as citizens, as the public, can't really have a fully informed democracy without the people who know the most about what those policies look like when they're put into place. And guess what? Those are public servants. So the right to public employee speech actually started, I feel, as a democratic right to make sure that the broader public could hear from and be informed by public servants, public employees about what was actually going on behind the scenes. And the Supreme Court rightly realized, wow, if we silence them, it's not just bad for the employees' First Amendment rights, it's bad for society because we're being deprived of news from the front lines, right, of the people who our policies impact. So it's a beautiful case, and it underscores your important role in informing our democracy. The second case I want to tell you about is pretty wild in the context of the current moment. And again, want to remind you, Randy started off by telling us none of this should be happening. Well, listen to this case. This case is called Rankin versus McPherson. In this case, an employee of a police department, I believe she was a civilian employee, not an officer, like she was an administrator, was in her office break room when John Hinckley tried to assassinate President Reagan and did shoot at him, but President Reagan lived through that, as I'm sure we all know. And Rankin, this employee, got up and said to two of her colleagues, well, I hope they get him next time. And they were clearly talking about the assassination, right? And this is someone who was still alive, who was still president. And she said, I really hope he dies the next time somebody shoots at him. Okay. So I mention this because this is about as, you know, rough and tumble and probably offensive to most people as the kind of comment you'd make in the immediate wake of an assassination attempt. And the Supreme Court, again, upheld her First Amendment rights and ruled that her termination was unconstitutional. And they said, look, do we approve of this speech? No, it's deeply offensive. But we also can't say that it prevented the police department from doing its job. She didn't make some public pronouncement on behalf of the department. And ultimately, you know, we can't say we want to give the government the power to say that what you did was inappropriate. It's not some floating kind of, you know, mandate that you operate at a certain level of, you know, seriousness or what justices would like to see you say as opposed to what you have a right to say. So in this moment, it's very hard as a First Amendment lawyer to look at the widespread targeting of employees for online speech about an absolutely admitted tragedy and assassination of a public figure. But it's hard not to see that retribution as anything other than a knowingly unconstitutional act against public employees, because there is a Supreme Court case right on point. What I will say is the real question is why, right? And I suspect I'd be asking myself if I were in your position, why? If those First Amendment rights are so intact, why are we seeing people be fired for that speech? Why are we seeing the Texas Department of Education engage in its witch hunt, as Randy rightly called it? I think there are two answers to that. One is there are some folks who are hoping they'll change the Supreme Court rules, right? That the boundaries of the First Amendment are always subject to change under a new Supreme Court and new appointees. On that point, I don't think most free expression watchers are biting their nails in terror. That is, at least on paper, the Supreme Court has upheld political speech in particular, but First Amendment rights at a pretty robust level. That said, there's a lot of complex case law about public employees that I'm sure we'll get into. It's not all sunshine and roses, but it's pretty strong. And again, remember, if you work for a private employer, there is no line. I mean, all you might do is have an employer that said, well, I didn't see you lionizing Charlie Kirk. You didn't say anything. You're fired. That's lawful, right? It may feel wrong, but that the First Amendment has nothing to say about that. But I think the second reason that this is happening, and perhaps the more important thing for us to grapple with, is that the government actors that pass these laws or sign these executive orders, right, they know it's unconstitutional, but they also know that there's no constitutional fairy. There's no magic wand, right, that walks around and says, this law is unconstitutional, it can't be enforced. We operate under the rule of law. And in this country, what that means and should mean, despite our current challenges, is that if a legislature or any government passes an unconstitutional law or policy, you challenge it in court. And guess what? Court cases aren't very fast. So what happens is you have a law like Florida's Don't Say Gay bill, which was passed by the legislature, which we all knew was blatantly unconstitutional, but immediately was in operation in the state of Florida unless and until it was stopped by a federal court. And that led to people being fearful, self-censoring, and unclear about what the boundaries of their First Amendment rights are.